All right, welcome to The Explainer. If you're prepping for the Queensland bar exam, this one's for you. We're going to dive deep into the rules on expert evidence. Specifically, we're talking about the Uniform Civil Procedure Rules 429D all the way through to 429H. These are absolutely crucial.
So here's the million-dollar question, right? You're expert. They're brilliant, a leader in their field, but is their evidence actually going to be admitted? This is something every single barrister has to get right. And lucky for us, the UCPR gives us a pretty strict framework to make sure the answer is a resounding yes. Because, let's be honest, getting this wrong, it can absolutely torpedo your client's case.
Okay, so how are we going to tackle this? Well, to make these rules stick, especially when you're under exam pressure, we're going to frame this whole thing around what I'm calling the 3 pillars of expert evidence. We'll look at the duty, the report itself, how it all plays out in court, and then, what happens when those pillars start to crumble? All right, pillar number 1, the foundation of duty. Look, you've got to think of the entire system of expert evidence like a building. And this is the foundation. It's all built on these really clearly defined duties, and it all starts with one simple question. When do these rules even apply? You have to know this bedrock inside and out. So, Rule 429D. This is where it all begins. And let me tell you, it is non-negotiable. What it says is that this whole framework kicks in the moment an expert is appointed. It doesn't matter who appointed them, whether it was you, the other side, or even the court. From that second on, these rules apply. No exceptions.
Now, this is where it gets really interesting because we've got these 2 sides of the same coin, right? We've got rules 429E and 429F working together. Under Rule 429E, your job as counsel is crystal clear. You must give the expert a copy of the Code of Conduct. And, this is the big one, you must not tell them what opinion to have. Your job is just to set them up for their duty, which is under Rule 429F. And what's that duty? It's to the court. Not to you, not to the client, not to the person paying the bill. Their primary duty is to the court.
And this quote, this is just perfect. It nails the whole idea of Rule 429F. Safronov P. in Mashagati, this is one you'll want to have in your back pocket for the exam, for sure. The duty to the court overrides any obligations owed to the party who pays the expert's fees. I mean, it doesn't get any clearer than that, does it? The court comes first. Period. Okay, so that's the foundation of duty locked in. Now let's build on that with our second pillar, the blue point of the report. So with those duties established, we've got to look at the nitty-gritty, the technical requirements of the expert's report itself. And for that, we turn to Rule 429H. This is literally the blueprint for a report that will actually get admitted into evidence. And it starts with something so simple you might almost overlook it. Rule 429H, Subrule 1. The report has to be addressed to the court, and it has to be signed by the expert. Why? Well, it's a constant reminder that this isn't just a letter to you or your instructing solicitor. It's a formal, serious document created for the judge's benefit. Okay. Now for the real meat of it, Rule 429H, Subrule 2. Think of this as the mandatory, can't-skip-it structure for the report. It's all about transparency, so the court can see exactly how the expert got to their conclusion. The report has to lay out the expert's qualifications, all the material facts they relied on, and, this is absolutely critical, the reasoning for each opinion. It's not enough to just say, this is my conclusion. They've got to show their work every single step. And before that report goes anywhere near the court, you as counsel need to run this final check. This is the mandatory checklist from Rule 429H, Subrule 4. It's non-negotiable. The expert must explicitly state right there in the report that they've read the Code of Conduct, that they believe the facts are true, that they've made all the right inquiries, all of these things. If these statements are missing, that report could be dead on arrival. It's that serious. All right, so you've got this perfectly compliant report. It's a work of art. Now what? How do you actually use it? Well, that brings us to Pillar 3, the execution in court. This is where Rule 429G comes into play, governing how this evidence gets presented. This is where the rubber really hits the road. Now, this is a really fundamental point, and it's a huge shift from how we deal with regular witnesses of fact. The general rule under 429G, Subrule 1, is simple and it's strict. An expert's evidence in chief is given by their report only. That's it. You don't just call them to the stand and have them walk through it all from the beginning. The written report is the evidence. Okay, so that immediately leads to a really practical question, doesn't it? If the report is the evidence, when on earth does your expert actually get to speak in court? Can you ever get them to clarify a tricky point or expand on something for the judge? Well, Rule 429G gives us the answers. It lays out the very specific path to getting your expert to give oral evidence. First, under Subrule 2, the report has to have been properly disclosed. No surprises. Second, under Subrule 3, your expert has to be available to be cross-examined. But here's the kicker and the most important part. Giving oral evidence in chief is not automatic. Under Subrule 5, you have to get the court's leave. You have to ask for permission. You can't just decide on the fly to have them elaborate. Okay, so we've built our 3 pillars. The structure is sound. But now we have to look at what happens when things go wrong. What are the high-stakes consequences when these foundational rules are ignored? Honestly, for your exam, this is the part of your answer that shows the examiner you get the practical importance of all this stuff. And let's be really clear about this. Getting these rules wrong is not some minor technical slip-up. It can be absolutely fatal to your client's case. The courts take compliance with this UCPR expert evidence regime very seriously. And the case law is full of examples of the significant penalties for getting it wrong. This isn't just about ticking boxes, it's about fairness and the integrity of the whole trial process. And this slide right here connects those rules to some very painful, very real-world consequences. You need to know these cases. Cases like Sutton v. Hunter and Brown v. Daniels are perfect examples where noncompliance led directly to adverse cost orders. What does that mean? It means the client couldn't get back the money they spent on the expert's fees. And even more seriously, you look at a case like Mashagati, the noncompliance was so bad it created an unfair trial, and the whole thing was successfully appealed. These are the kinds of powerful examples you absolutely need to be citing in your exam. So, when it comes right down to it, this is the question you have to ask yourself. Is this expert report an asset, or is it a liability? And the rules, they're what decide. So here's the key takeaway. Strict, unwavering adherence to Rules 429D through 429H is what turns an expert's opinion from a potential landmine into a powerful, admissible asset for your case. Mastering these pillars isn't just about passing an exam, it is absolutely fundamental to your entire future practice as a barrister.